Picture it. You've just signed the papers, gotten the keys, and stepped into your beautiful new home in upstate New York. 3 stories, Victorian, creaks just right. Bit of charm, bit of character, and apparently a couple of permanent residents from the afterlife. That's exactly what happened to one chap by the name of Jeffrey Stambovsky, who in the early 1990s made the dreadful mistake of buying a house that turned out to be legally haunted. Yes, you heard me, legally haunted. Turns out the previous owner, Helen Ackley, had been telling the neighbors, tourists, and even magazines that the house was full of ghosts. Her stories included Revolutionary War-era spirits, floating objects, and a spectral presence that woke her up for school exams. That's not an alarm clock. That's an exorcism waiting to happen. But when she sold the house, not a boo was mentioned. Mr. Stambovsky, unaware of the house's poltergeist PR, signed on the dotted line. Then word got out. Suddenly the neighbors were whispering, "Oh, you bought the haunted house." Cue panic, lawsuits, and a firm I did not sign up for this moment. So what did he do? He sued. Now here's where it gets absolutely brilliant. The judge didn't just sympathize. Oh no, the court ruled that since the seller had made the house famous for being haunted, it was only fair to treat it as such in a legal sense. They actually wrote in the ruling, as a matter of law, the house is haunted. That's right. This house became the first and only in US history to be declared officially haunted by a court of law. And you thought buying a house with plumbing issues was a nightmare. In the end, the contract was rescinded. Our ghost-wary buyer walked away, and the case went down in history as Stambovsky versus Ackley, or, as I like to call it, the poltergeist property precedent. Moral of the story: if you're selling a house and it comes with unwanted guests, apparently you'll have to mention it in the brochure.